Hi, David Campanile here, owner of Campanile Law, located in the great state of New Jersey. We handle estate planning and probate. As always, if you'd like to schedule a strategy session with me, you can contact me at njestateattorney.com. So today I wanted to talk to you guys a little bit about something I see, and a question that I get a lot is, does a new will revoke any of my previous wills? So, that's an interesting question because there is verbiage that is placed in a will. It's usually at the beginning, in the first paragraph, that says this: the execution of this will revokes any and all codicils and any previous codicils and wills made, or some variation of that wording. And why is that wording important? Well, that wording's very important, and I place in all of my wills, even if it is your first one, because we want to protect you. We want your most recent intention or intent to be adhered to when you pass. And as I've stated numerous times, estate planning is one of those fields where you don't see what happens until you're not around anymore, so your family's the only one who sees. So we always want your most recent intent to come through in your will or in a codicil. And because by stating, does this revoke, by stating this revokes any and all previous, basically we're saying is this is the new intent, everything else is null and void, and this is what I want you guys to listen to. Some attorneys and some bad wills that I've seen written from LegalZoom or from Rocket Lawyer or any place where you could just buy something for like $50 or something like that, tends to leave this verbiage out. And the issue I have with that is, yes, we can assume that under the new date, this was your most recent intent. However, because you didn't revoke anything, now we're playing on the line of trying to let the potentially letting the courts in, and now them interpreting 2, 3, 4, 5 different wills. If none of your wills have had this verbiage, if you've had your 4 previous wills that said that, and now you don't have that, well, now we're interpreting the most recent and the previous one before it. So it's kind of important, just because even though we may, we can operate under the assumption that the new date revokes the previous wills, and now we're bound to the new will. It's better to add this verbiage in. And we don't want the court to be involved. That's the last thing we want to do, because that's more money, that's more time that your family, your beneficiaries, your heirs have to go around and fight and spend, and it's doesn't put the bow on the healing process, as these fights can drag out, especially if there were changes to a beneficiary's amounts or percentages. That's it. If you found this video informative, please hit the like button. If you wouldn't mind, like us on Facebook, Campanile Law LLC. Subscribe to us on YouTube. Give us a thumbs up if you're viewing on YouTube. We're putting out new data every day. We're putting out new content every day, 5 days a week. I do have to take some time off. But yeah, so if you found this informative, please share it out. Please, if you know somebody that is looking to change their will, or this may benefit them, please share it with them. Tell them you were thinking about that person. As always, I'm David Campanile, owner of Campanile Law, located in the great state of New Jersey. We handle estate planning and probate. If you'd like to schedule a free 45-minute strategy session, come on, reach out to me at njestateattorney.com.